In the summer of 2023, sheriff's deputies in Volusia County, Florida, pulled up to a tiny island near the Dunlawton Bridge in Port Orange. And what they found there did not look like a campsite. It looked like a settlement. There was a 4-story treehouse built from old lumber and tree branches. There were huts. There was a hand-painted welcome center sign directing visitors where to go. Someone had installed a trampoline. Someone else had started digging out a swimming pool. And on the islands nearby, the people living there had set up booby traps to keep strangers away. Locals had a nickname for the place. They called it Meth Island. When officials finally showed up, they couldn't just tear it down. They had to post a notice. They had to give a warning. They had to follow a process. Because in 2023, the people squatting on that island had something the law actually recognized. For decades in this country, if someone moved onto property that wasn't theirs and simply refused to leave, getting them out wasn't a phone call. It was a lawsuit. It could take months. It could cost thousands of dollars. And in the meantime, the person who actually owned the place could do almost nothing. That was the reality across most of America. A stranger in your house had more immediate protection than you did. This is the story of how that ended. How one Florida law kicked off a wave that swept state after state. How squatting went from a months-long civil nightmare to immediate, on-the-spot criminal removal, and the bizarre real cases that pushed the whole country to its breaking point. Let's get into it. To understand why people snapped, you have to understand the old rules. And the old rules came down to one phrase you've probably heard thrown around online: squatters' rights. The legal name for it is adverse possession, and it's genuinely old, going back centuries to English common law. The original idea wasn't crazy. If a piece of land sat completely abandoned and someone else openly lived on it, maintained it, and paid the taxes on it for years and years, the law eventually let them claim it. The thinking was that land shouldn't sit useless forever while the real owner ignored it entirely. In Florida, for example, the timeline to actually claim a property through adverse possession was 7 years, and you had to pay the property taxes to do it. That part rarely happened. But here's where it went wrong. The problem was almost never someone actually winning ownership. The problem was the eviction process in the meantime. Because under the old system, the moment a squatter claimed they lived somewhere, even with no lease, even with no proof, the situation flipped from a police matter into a civil one. And once it's civil, the police step back. They tell you it's a dispute between two parties. They tell you to take it to court. In Georgia, before the law changed, property owners waited an average of 8 months to get a squatter removed. 8 months of mortgage payments on a house you can't enter. 8 months of utility bills for someone else's hot showers. 8 months of watching your property get damaged while a court date crawls closer. And squatters learned to game it. The most common trick was a fake lease. When the police arrived, the squatter would simply produce a phony rental agreement. And the second that piece of paper appeared, the officer's hands were tied. Now it looked like a landlord-tenant dispute, and that meant court, and court meant months. You owned the home. You held the deed. And a stranger with a forged document printed off the internet had effectively locked you out of it. That was the system. And by 2023 and 2024, Americans were done with it. The reason this became a national story wasn't the law itself. Property law is dry. What made it explode was the cases. And once local news started running them, they didn't stop. There was the New York homeowner who was arrested at her own property. Her parents had left her the house. When she changed the locks to keep out people she said had moved in illegally, she was the one who ended up in handcuffs because the occupants claimed tenant status. Think about that for a second. The owner got arrested, not the squatters. There was the Florida man who came home from working overseas to find a stranger living in his house. When he confronted the squatter, he was warned he could be the one facing charges if he forced his way into his own home. And then there was Meth Island. The welcome center, the trampoline, the pool. An entire illegal village built in plain sight that officials had to carefully, slowly, legally dismantle. These stories went viral for a reason. They tapped into something that crosses every political line. The idea that you could work your whole life, buy a home, and then lose control of it to someone who just walked in and refused to leave. And worse, that the system would side with them over you. The pressure built, and the first state to actually do something about it was Florida. On March 27, 2024, Florida Governor Ron DeSantis signed House Bill 621 into law. It was set to take effect that summer, on July 1, 2024. And what made it remarkable wasn't just what it did, it was the fact that the Florida legislature passed it unanimously. In a state, in an era where almost nothing is unanimous, this was. Here's what House Bill 621 actually changed. Under the new law, a property owner no longer had to file a lawsuit to remove a squatter. Instead, they could fill out a simple form, hand it to the local sheriff, and request immediate removal. No judge, no hearing, no 8-month wait. The sheriff was now instructed to go and remove the people occupying the property. But the law had guardrails, and these matter. To qualify for this fast removal, the situation had to meet specific conditions. The person had to have unlawfully entered the property. The owner had to have already directed them to leave. There could be no pending lawsuit over the occupancy. And critically, the occupant could not be a current or former tenant in a legal dispute and could not be a family member of the owner. In other words, this was built to target true squatters. Strangers. Not a tenant behind on rent and not your brother-in-law who overstayed his welcome. And then House Bill 621 went after the fake lease trick directly by turning it into a crime. Under the new law, presenting a falsified document to claim property rights, like a forged lease or deed, became a first-degree misdemeanor, punishable by up to a year in jail. The penalties scaled up from there. Anyone who unlawfully occupies a home and intentionally causes $1,000 or more in damage now faces a second-degree felony. And anyone who knowingly advertises or tries to rent or sell a property they don't own faces a first-degree felony. DeSantis framed it bluntly, saying Florida was ending what he called the squatter scam, and that while other states were siding with squatters, Florida was protecting property owners. Now, the law wasn't perfect, and there was a real cost buried in the details. If a sheriff's deputy has to stand by and keep the peace during a removal, the property owner can be charged a fee plus an hourly rate. But for homeowners who'd been staring down an 8-month court battle, a fee and an afternoon was a trade they'd take every single time. Florida had drawn the blueprint. The question was whether anyone else would follow it. They followed it fast. Florida wasn't actually alone in 2024. It was the most famous, but it was part of a cluster. That same year, 5 states moved to criminalize squatting and create fast-track removal. Alabama, Florida, Georgia, Tennessee, West Virginia. Georgia's law was actually the first of the group to take effect back in April of 2024. Under it, a squatter gets served with a citation, and unless they produce legitimate documentation within 3 business days, they have 3 days to get out. The 8-month nightmare gone. Tennessee built in something clever to prevent abuse. Under its law, the owner files a complaint, the sheriff orders the squatter to vacate immediately, and arrest is on the table. But if a property owner wrongfully removes someone who actually had the right to be there, they owe triple the fair market rent, plus damages and fees. A real penalty, pointed in the other direction. Then 2025 hit, and the trickle became a flood. In July of 2024, a national policy group adopted a model bill, a template that any state legislature could pick up and pass. And across 2025, roughly 10 more states enacted laws closely tracking that model. Arkansas, Indiana, Kentucky, Maryland, Mississippi, Montana, Texas, Wyoming, state after state signing nearly identical language into law. Indiana's version, effective July 1, 2025, set up an affidavit-based removal that can happen within 48 hours, while still building in a remedy for anyone wrongfully removed. North Carolina's law took effect in December of 2025. Under it, the owner files an affidavit, the sheriff serves the occupant, and a magistrate holds a hearing within roughly 48 hours, with a vacate order following shortly after. Fast, but with a judge in the loop as a check. Maryland went a slightly different route, requiring a wrongful detainer hearing within 10 business days. Slower than Florida's same-day removal, but still a world away from the old open-ended wait. Step back and look at the scoreboard. As of mid-2024, only a handful of states had real anti-squatting criminal laws on the books. By the summer of 2025, that number had climbed to 23 states. In a little over a year, nearly half the country rewrote the rules. But notice the other half of that map. Because where you live still decides everything. In one state, a squatter is out the same afternoon, cross a border, and a homeowner is right back in the old world of civil court, lawyers, and months of waiting. So what does this actually mean for you today, if you own property or you're about to? First, the single biggest factor is your state. Before anything goes wrong, find out whether your state has passed a fast removal law and what it actually requires, because almost all of them demand specific steps in a specific order. A form, an affidavit. Formal notice to leave before police get involved. Second, and every expert in this space says the same thing, prevention beats removal every time. Vacant properties are the targets. Regular inspections, security cameras, and someone keeping an eye on an empty home are still your best defense, no matter how strong your state's law is. And third, know the line the law draws. These statutes are written to remove strangers, not tenants. If there's any real rental history, any dispute over a lease, the fast track usually doesn't apply, and you're back in regular eviction court. That distinction is the whole game. Because here is the honest catch, the part that doesn't fit neatly on a thumbnail. Critics of these laws aren't defending squatters. They're worried about the machinery itself. When you let police remove someone from a home in an afternoon, based on a single form, the entire system depends on getting that decision right, instantly, on the spot. The fear is the edge cases. A legitimate tenant whose paperwork is messy. A renter in a dispute that the responding officer has to untangle in minutes. Get it wrong, and you've used a fast, forceful process to throw a lawful resident out of their home. That's exactly why states like Tennessee and Indiana wrote in penalties for wrongful removal, and why North Carolina kept a magistrate in the loop. The states that thought hardest about this built the brakes in alongside the engine. For decades, the scale was tipped one way. A stranger could occupy your home, and the burden, the cost, and the waiting all landed on you. The 2024 and 2025 laws tipped it back, hard, and that correction was overdue for a lot of homeowners. The open question now is the balance. Move too slowly, and you're back to the 8-month nightmare. Move too fast, and you risk removing the wrong person from the right home. Almost half the country has now picked a side. The other half hasn't. And whether your home is protected the same afternoon or tied up in court for the better part of a year still comes down to one thing: the state line you happen to live on. If you found this breakdown useful, there's one question worth dropping in the comments. Should removing a squatter take an afternoon, or should a judge always have to sign off first? I read them, and the split on this one is always closer than